I'm Drew Stevenson, and this is a video for my Law and Economics seminar course about the economic analysis of contract law. And here we're going to be talking about the doctrine of consideration in contracts. Now, for my students, you must have studied this, the contracts in your first year of law school already, and you remember learning about consideration for contracts. It's one of the ways, kind of the initial steps that a court uses in determining whether there even is a valid contract that the court should have to enforce. And obviously, this is a technical legal term. In common parlance or outside of the legal realm, consideration means thinking about others, being considerate, right, or empathetic and nice to others. But in law, this is a technical term, specifically in contract law, that means that there was actually some sort of bargain for exchange or a quid pro quo, that each of the parties was giving something in exchange for what they were getting. And this video is going to be talking about some economic reasons why we have this rule, why we require consideration. So let's look at my slides. Basically, a one-sided promise is not an exchange, right? And so if one side says, I'll do something, and the other party didn't do it, then we really don't have any bargaining. And from an economic standpoint, we haven't necessarily increased overall social welfare, right? So the party who's giving something is not really getting anything back and is not better off because of the transaction. Whereas in a classic transaction, from an economic standpoint, both parties go away better off than before they had the exchange. Right? So if you're a farmer and you have a barn full of grain that you need to sell, or a silo full of grain, you can't eat all of that grain yourself, right? But let's say that someone else has something that you would like fuel for your tractors. Now, I know that in real life we use money as our medium of exchange, but I want you to imagine a barter scenario where the person who sells fuel, who has fuel for tractors, the fuel vendor, actually needs to feed their family, and they are so busy producing fuel that they can't spend all their time farming and growing the grain, the food for their own family. So they're better off if they have a surplus of fuel, trading some of that fuel for food from the farmer. And then the farmer in turn has more grain than he can eat or his family can eat. So he's better off trading some of his surplus grain for fuel, which he really needs. So it's important for students to understand that we don't think that in a contract that whatever one party gets makes the other party worse off. If so, we would call that a zero-sum game, right? Where any advantage to one side or profit for one side is another side's loss. The fact is that both parties can walk away from an exchange way better off, right? So let's say you have a bunch of old clothing that you don't want to wear anymore because it doesn't fit you, so you can't wear it. And then you have somebody else who loves vintage clothing, and all of your old clothes are the perfect size for them. And so they offer to buy that from you. You're way better off now than you were with a closet full of stuff that you couldn't wear, even if you wanted to. And maybe they're way better off with the vintage clothing that they're really going to enjoy wearing than they were with just money sitting in their bank account. There's a sense in which consideration and contracts are a restraint, a self-restraint on our own freedom. In other words, you have bound yourself legally to do something in the future, or maybe to not do something in the future, depending on the contract, on what you agreed to do. And so in that sense, right, if you think that freedom is absolute and we should always have as much freedom as possible, then you should never make a contract, because a contract necessarily binds you to do certain things or obligates you to do certain things. And in that very limited sense, in one aspect, restrains your freedom in the future. You can't just do whatever you want. You have an obligation under a contract that you made that's legally enforceable. So why would anybody do that? Well, because again, we're better off. We enhance our own utility through curtailing our own freedom. So you promise to do something, and maybe it's something that you don't really mind doing, like going to work. and because you had nothing else to do, and you're going to get paid a lot of money for going to work, and so you're willing to restrain your freedom in exchange for that, and your employer is happy to bind themselves to give you some of their money after you've done some work, because they're better off having your productivity at the workplace. There's a forensic or evidentiary reason to require consideration for contracts. If there's something of value that both sides have to contribute in the exchange, it makes it easier for a tribunal later to determine that there was indeed an agreement. In other words, if we can say, okay, you were going to do this service and you were going to give X amount of money in exchange for that service, that looks like a contract. And if we didn't require consideration, it makes it much more complicated after the fact to figure out what was said and what was exactly, and what the parties understood, and what they thought they were agreeing to, and what they expected of each other. So if we can require something kind of concrete from each side in terms of consideration, it does make it easier from an evidentiary or forensic issue for an adjudicator or arbitrator later on to determine that there was indeed an agreement, instead of one side just saying, I think this person should have to do this for me. Requiring consideration helps minimize inadvertent contractual commitments that we might make due to careless or casual use of promissory language, right? So when somebody tells you that they're going through a hard time, or describes some tragedy that has happened, it's very common for us to say little things that are just social niceties, like, I'll always be here for you, or if there's anything I could do for you, please let me know, right? So we say stuff like that to be nice. And maybe we mean it a little bit, but we don't really mean like that we're going to give them our house and our car, right? So to make them feel better, or that we're willing to become their like personal butler for the rest of our lives, or something. And so we say a lot of things that we don't really mean to be taken literally. And requiring consideration helps us not end up in court every time we say something like, oh, I will love you forever, or I would love to have lunch with you sometime, or sure, if you do this, I'd love to do that. And we didn't really mean it. And nobody should have expected us to mean it. It also reduces the risk of mistake or coercion or duress in making the contract, right? So if you had to sign a contract because somebody had a gun to your head, right, that's not really fair, right? That's a type of duress or coercion, and there probably isn't adequate consideration in that sense, or else they wouldn't have had to put a gun to your head to make you sign the contract. Requiring consideration helps preserve judicial economy. It saves the courts from having to enforce lots of those trivial promises that I mentioned that are made in informal social settings. So I am a parent. I raised some children, and I can tell you that there were lots of times where I said, I was hoping that we would, go to McDonald's later or do something fun that weekend. And then we got rained out, or something came up and we had to change our plans, right? And so you don't want children to be able to sue their parents every time the parents have to break a promise, and vice versa, right? Because a lot of these are not really serious things that we intended to be legally binding, even if we did mean them when we said them. A doctrine of detrimental reliance focuses enforcement to promises that induce another party to incur substantial costs. In other words, we're kind of focusing the government judicial resources and executive branch resources that are utilized in kind of forcing people to fulfill their contractual obligations to the things that really matter, right? Where somebody else has incurred a significant cost in exchange for that. It's requiring consideration helps screen out cases in which the obligations of one party are left entirely vague. And so if you have this could be a situation where somebody's trying to defraud another person or cheat them by saying, oh, we'll settle the details later. Don't worry about the details. They'll take care of themselves, or we'll figure it out as we go along. Or it could be a situation where you just have a lawyer who does sloppy drafting work, right? And negligent drafting work. They're lazy. And so they don't really put much effort into it, or try to choose the terms carefully. and so forth. And so if there's no consideration, we're going to kind of screen out some of the cases where one party didn't really promise to do anything. And we can deter opportunistic behavior like hold-up games, right? The situation where um, somebody takes you. I had this happen to me one time when I was traveling somewhere, and I was a tourist, and somebody agreed to take my travel companion and I out for a boat ride, and then they wanted a lot of money to bring us back, right? And more money than we agreed to. That's a classic hold-up game, right? You pay somebody to take you on their boat, their little boat, out to an island that you is a tourist attraction. You see the island, and then when you want to go home, they want a lot more money to take you back. And so, if when in our legal system, when we require consideration, it helps deter this type of opportunistic behavior. There's an aspect of information economics that's worth thinking about too. So the declared intentions of the parties should, in fact, receive more weight than the notions of efficiency that a court may have. So a court may be able to look at the transaction that the parties were trying to do, and maybe the judge is very experienced and could say, well, I could have come up with a better contract than that. Like the optimally efficient contract, I think, would be such and such, right? And so, but the fact is that the parties have private information that may not be available to the courts. So there's a sense in which when we can determine, due to consideration, what the parties intended to give in exchange for something else, court should defer to that instead of what they would have done in the situation, because under the idea that people know what's best for themselves. And that concludes my kind of short lecture about the law and economics of the rule of consideration.